discriminated against because of their sexual orientation. Essentially, it's about equal pay for equal work. It also helps strengthen the quality of the workforce in civil and government sectors. The federal government is the nation's largest civilian employer and should be a model for equal opportunity, pay, and compensation practices. Yet we are lagging behind the private sector. A majority of Fortune 500 companies already extend benefits to employees with same-sex partners. It makes good business sense for us to be competitive with the private sector for top talent, and this legislation is a step in the right direction. As a former state assembly member in California, I co-authored and voted for equal benefits for domestic partners and fought hard against discriminatory practices towards the lesbian, gay, bisexual, and transgender workforce. As a member of this committee, I look forward to doing the same on the federal level. By ensuring equality and fairness in the federal workplace, same-sex domestic partners of federal employees can access the benefits they're entitled to, and we can all stand as truly equal Americans. Thank you, and I yield back.
Thank you very much. And of course, I'd like to now recognize the gentlewoman from California again, Ms. Watson.
Thank you, Chairman Towns, for bringing before us today important legislation for consideration, the Domestic Partners Benefits and Obligations Act. And thank you, Representative Baldwin, for taking the leadership on this issue for years. Perhaps nothing is as important about this bill as what it is not about. It does not propose or intend to diminish or alter in any way the benefits historically and currently enjoyed by federal employees and their spouses. It does not seek to redefine marriage or the Defense of Marriage Act known as DOMA, which continues to recognize marriage as an exclusive union between a woman and a man for purposes of federal law. It does not in any way intrude upon and continues to honor states' rights in the definition of marriage and the benefits associated with it. Nor does it add substantially to federal expenditures, since the benefits accorded under this law are projected to increase costs to the federal government by only 0.2%, and the administration has committed to ensuring that it complies with the House pay-go rules. What this bill does do is make sure that the federal government does not play favorites among those who do the necessary work of the nation based on factors that are relevant to that work. What this bill does do is end discrimination based upon the gender of those who are the chosen life partners of federal employees. The very substantial benefits that the United States extends to its workers in recognition and support of their families have heretofore only been legally available to those who are heterosexually coupled or who felt obliged to pretend to that status. It is time to unburden those who bear the burdens of the American people through government service. The United States has a history of slow, controversial, and partial progress towards recognizing the equality under the law of all of its citizens. But our pride and redemption as a nation is that we continue in that struggle. Today, we take yet another stride forward towards the goal of treating all human beings as equal and all families as valuable and worthwhile. Those who do the work of America deserve no less from America. So I want to thank you, Mr. Chairman, and our ranking member, and I'm proud to co-sponsor this legislation, and I would urge my colleagues to get rid of your discrimination and your bigotry, and I urge my colleagues to support it, and I'll yield back.
Thank the gentlewoman from California for her statement. Now I recognize the gentleman from Virginia for 5 minutes, Congressman Connolly.
Thank you, Mr. Chairman, and thank you for holding this markup today. I applaud you and Congresswoman Baldwin for her outstanding leadership on this important issue. I'll enter without objection for the record 2 letters of support for this bill, H.R. 2517.
Without objection.
From the NTEU and the AFG Employees Group. Over the next 10 years, fully 47% of the federal employees will be eligible for retirement, largely due to the demographic factors. In the highly competitive labor market, especially here in this region, we cannot expect to recruit the best employees if the federal government offers inferior salary and benefits packages. Today, most federal contractors offer benefit packages that grant domestic partners health and other benefits. It would be short-sighted for us to block recruitment and retention of these highly skilled employees, and odious that such obstructionism would spring from thinly veiled prejudice. Today we'll consider several amendments to H.R. 2517. The managed amendment offered by you, Mr. Chairman, will ensure that this bill will apply to all federal employees, and again I congratulate you and Congresswoman Baldwin for putting it together. I intend to support it. In contrast to this thoughtful, well-intentioned amendment, some may offer poison pill or weakening amendments. After stepping back for a moment to observe with wonder and sadness that a once shining force for civil rights remains now intransigently opposed to equal rights for all American citizens, we may return to the practical implications of these amendments. First, as they did in subcommittee markup, an amendment is likely to be offered by some to extend domestic partnership benefits to heterosexual, unmarried federal employees. This amendment is no less transparent in its intent than it was when we rejected it in subcommittee markup. Heterosexual federal employees can get married. Homosexual federal employees cannot. The whole purpose of this bill is to prevent the grossest violations of federal employees' civil rights, such as the inability of partners to visit one another in the hospital, which are the direct result of a long-standing discriminatory effort by some to prevent all American citizens from achieving equal rights. The amendment to extend benefits to heterosexuals would simply make this bill cost prohibitive and should be defeated. The unintended irony of such an amendment is that it implicitly acknowledges that there is, in fact, a problem that needs to be fixed. The minority may offer other apparently innocuous amendments also designed to torpedo this modest legislation. Those amendments also, I think, should be defeated. Mr. Chairman Towns, thank you again for holding this important markup. Following in the footsteps of this region's private sector employers, by taking this modest legislative action, we may empower our federal agencies to recruit and retain the most highly qualified employees without fear of discrimination or prejudice. I yield back.
Thank you very much. Thank you, gentleman from Virginia, for his statement. And I recognize the gentleman from Nebraska, Missouri, Mr. Lukemeyer.
Thank you, Mr. Chairman. I look forward to debate on this bill. I think but I think we're traveling down a path that we don't really want to travel down with this particular piece of legislation, from the standpoint that I think we have many flaws with this particular piece. We don't have a cost estimate yet of what this is going to cost us. A lot of the definitions for the terms in here are open-ended. They don't have any, we've got unintended consequences, I think, from the fact that we don't have sound definitions that tell us what a domestic partner is, for instance. The affidavit, the term is rather vague and legally meaningless the way they've defined. So I'm looking forward to the debate and looking forward to the amendments to see if we can shore this thing up in order to be able to take a look at it in its final form. With that, I would like to yield the balance of my time to the gentleman from Indiana, Mr. Burton. Thank you.
I thank the gentleman from Missouri for yielding. There's an affidavit, Mr. Chairman, that's supposed to be signed by these people, and that's one of the main problems that I have with the bill. The affidavit may lead to disciplinary action and the recovery of cost of the benefits received related to such falsification and may constitute a criminal violation, is what it says. Now, the affidavit stipulations lack the specificity necessary to be legally defined. The definition of a domestic partner remains unclear because a committed relationship is a colloquial term, not a legal one. This is therefore a vague term to define or enforce unless committed relationship can be specifically defined or redefined. Currently, spousal benefits are based on the documentation of a state-sanctioned legal marriage. Because of this, spouse equity benefits determinations frequently rely on state court-ordered awards. There is no similar provision in this bill. In practice, the vagueness of the affidavit stipulations could result in the potential for significant abuse. The employee is responsible for ensuring that the standards of the domestic partnership are met via his or her assertion in the required affidavit. It's unlikely that the Office of Personnel Management or any law enforcement entity would be able to go to each eligible couple's home to determine if fraud is being committed. The determination of fraud in most instances would be very invasive. In September of 2008, OPM testified before the Senate Homeland Security and Government Affairs Committee and stated that it had concerns with the administration of benefits for a domestic partnership. And they said, quote, "Currently, spousal benefits are based on the documentation of a state-sanctioned marriage. The bill under consideration would provide benefits to those in domestic partnerships or relationships which are certified by affidavit. OPM believes this process could lead to fraud and abuse in the programs we administer." And so there's a real danger of fraud being committed that's going to cost the taxpayers a great deal of money. Obviously, I'm for traditional marriage approaches to solving, problems. But one of the big concerns I have with this bill is, how do you determine whether or not fraud is committed? How do you determine who gets benefits in the event that there's a separation? Let me just give you a case in point. As I said before, I got married about 3 years ago, and I had to wait 90 days before my wife got benefits. Okay, after 90 days, I had to pay 10% of my salary would go to her benefits, and if I died, she would get 55% of those benefits, or if we divorced, she can make claim to 55% of the benefits. Let's say some domestic partner comes in, and they get together, and they start living together for a year or two, and there is a separation, and they follow the rules that's put forth in the affidavit. Let's say that one of them goes to court and says, "I want to claim my benefits." What happens if the person in question has another domestic partner that comes along? Would they be entitled to the benefits, and how would that be determined in a court of law? Now, maybe there are some answers to this. I don't know. But all of these questions must be addressed before we pass any legislation. Otherwise, we're going into a quagmire legally that's going to cause more problems than it's going to solve. And OPM has stated they're going to have a heck of a time enforcing this because of the possibility of fraud. And with that, I yield back to the Councilman. Yes.
Just one other point the gentleman brought us to is I hope we all understand that this legislation specifically allows for a domestic partnership not to include people living together. It actually allows for them to have separate domiciles and yet still be named, and the language naming that is vague. So I would hope that as there's a rush to try to provide this right and privilege, that we look at the flaws in the bill. Yield back. Thank you.
Yield back, Mr. Chairman.
Thank you very much. And let me just to reassure my colleagues that, first of all, many corporations are doing this already. There's a thing called common law. I mean, so this is not something that has not been done and not going on. And I think that OPM really doesn't require any documentation, so that's not going to be a problem for them at all. So let me just say that I think the time has come when we're prepared now to move forward. I call up H.R. 21.
Would the Chairman yield for one question?
I'd be delighted to yield to the gentleman.
Mr. Chairman, OPM has testified before the Senate that this was going to cause a lot of problems. Has anybody on the committee talked to OPM about their concerns? Anybody?
Yeah. Well, no, actually, the only thing I can say to you is this. I don't know in terms of what happened on the Senate. I stay away from there. I don't go over there. But the point is that they support this legislation. And that's the thing I think is most important. But I stay away from the Senate side. Yes, I'd be delighted to yield from the gentleman from Massachusetts.
Thank you, Mr. Chairman. I just want to recognize a couple of things. Number one, the gentleman from Indiana is correct that OPM, since its inception, has relied upon state-sanctioned marriages. But the point is that many states for many years, have recognized common law marriage, which is just people acting like they're married. No certification, no ceremony, nothing. And those federal employees, please let me finish, I have 2 points. Those federal employees have never been forced to come in and do an attestation or any proof beyond the fact that their state, you know, whether it's California, Arkansas, Massachusetts, Rhode Island, recognizes their marriage at common law. That's point number one. And there's much more of a requirement here on the part of the gay and lesbian couples. Secondly, there was a statement made that you don't even have to be living together. Let me just read from the bill. There's going to have to be an affidavit that such individuals have a common residence, or, and remember, we're talking about federal employees here, or if they don't have a common residence because of financial, employment-related, or other reasons as identified in the affidavit. We have a lot of folks that work for State Department, a lot of people that are overseas working for Treasury. We have a lot of federal employees that are deployed overseas, and so for that period, those people aren't living together.
Well, if the gentleman yield, isn't other any and everything? The whole point was it does not have a requirement that they be co-domiciled, and in fact the affidavit allows for other, and other is the most undefined term I think we've ever seen.
The affidavit requires, and you can see it at page 4, it requires both individuals be the same sex, both individuals have at least 18 years of age and competent contract, the filing employee, the former employee or annuitant has notified the other individual of the filing of the affidavit. Such individuals are in a domestic partnership. Such individuals have a common residence. They don't, and if they don't, there's a financial or employment-related or other reasons as identified in the affidavit. Neither individual is married to or in domestic partnership with anyone outside of the domestic partnership. The two individuals share responsibility for a significant measure of each other's common welfare and financial obligations. The individuals are not related in any way that they were, if they were opposite sex, would prohibit legal marriage, and it goes on and on. So there are requirements in the affidavit for these people to attest to this under pains and penalty of perjury. Unlike in the common law example, no filing, nothing. You just got to act like you're married, and that basically gets you covered as a federal employee. So you do have two standards, but I think that the drafters of this legislation have tried to compel people to make a definite and legal commitment publicly, to file that, to sign that affidavit under pains and penalty of perjury. And you know, I don't think there's a whole lot of people out there, given the amount of discrimination we have against gay and lesbians in our society, that's just a fact. I don't think there's a whole lot of people out there trying to pretend that they're gay or trying to pretend that they're lesbians so that they can get favorable treatment. That is not the reality of today's world. That's why we are here, because they are at a decided disadvantage. The other point I want to make is on the pay for on this. Number one, we just attached a provision on a bill that we attached a provision that we had drafted for federal employees on the Defense Appropriation Bill because that vehicle was moving. It was a Roth IRA. Now, the Roth IRA for federal employees, because that money, all contributed by federal employees, will be contributed as taxable contributions. That measure alone, that Roth IRA for federal employees over the next 10 years will bring in $1 billion, new dollars, revenue by federal employees into this system. That one measure alone, I'm not even going to talk about straightening out the Federal Employee Health Benefit Program, which if we do half of what we need to do, will bring in at least that much, $1 billion. So this is being paid for by federal employees, by their new tax dollars that are being brought in this year. With that,
Would the gentleman yield for one? Will the gentleman yield for just one?
Mr. Chairman,
I have control of time. Gentleman from Utah, and then we're going to move on after. Because let me just say this before I yield. I'd be delighted to yield to you in a moment. But let me just say this: if this opens up to a universe of fraud. Why do we see growing numbers of businesses offering these benefits every year, more and more? I mean, and also, let me just say to you, there's an amendment here, and that we can discuss this further, but I'd be delighted to yield to the gentleman from Utah.
Mr. Chairman, thank you. I'll be very brief to the gentleman from Massachusetts. If he would just consider that in the 3 points, all I ask is that he look closely at those to say financial, employment-related, or other reasons. When we say or other reasons, we see absolutely no bounds or limits to that. It's as if there's no requirement. And all I ask is that he give some consideration to the unbounding opportunities for somebody to take advantage of that when you say other reasons. There is no limit to that. With that, I'll yield back. I just wanted to make that
Gentleman
One
from Indiana, recognize.
quick question.
We're going to move forward.
Mr. Chairman?
Yes, be delighted.
One quick question. The gentleman from Massachusetts referred to common law. Common law in most states is somewhere between 6 and 7 years. And there's no definition in this on, as far as time frames are concerned. So when you say that there's no difference than this in common law, there is a significant difference, because common law is defined by a given time period. There is no given time period in this as far as extension of benefits is concerned. And look, I don't think many, if any of us, are here to criticize people's lifestyles. What we're saying is, if you're going to pass something like this, and I don't support it, but if you're going to pass something like this, let's make sure that we clear the thing up so that it is limited in scope, so it isn't so broad it's going to cause all kinds of problems. And I think this thing has an awful lot of open space in it that needs to be dealt with.
Let me just clear up a couple of points that have been made here. We're going to move on. OPM currently does not require any documentation for married employees, whether it is common law, state-ordained marriage. It doesn't make any difference. They don't ask for anything. And OPM fully supports the bill and did so in a testimony here. Now, I know this comment about the Senate side, but I don't know in terms of anything about that. But I don't see them testifying one way on the Senate side and another way on the House side. So let's move forward. Would the clerk read the bill?
I just want to correct one thing, Mr. Chairman. Maybe OPM doesn't have any concerns about that, but our rules in the House of Representatives do, because you have to have a certain period of time before people get these benefits or are allowed to apply for these benefits. And this does not deal with that, and it needs to.
Yeah, Mr. Clerk, read the bill.
H.R. 2517, a bill to provide certain benefits to domestic partners of federal employees.
I ask unanimous consent that the bill be considered as read and open for amendments at any point. I now recognize myself for an amendment, which is at the desk. The clerk will designate the amendment.
Amendment in the nature of a substitute to H.R. 2517, offered by Mr. Towns of New York.
Without objection, the amendment is considered as read. We pass the amendment out.
We got to do this piece. You can go while they're passed.
Now, I ask unanimous consent that the Towns Amendment in the nature of a substitute be considered as base text for the purposes of any additional amendments to this bill. Without objection, so ordered. The substitute amendment makes important technical changes to the bill. It is modeled on the changes already adopted by the Federal Workforce Subcommittee during the consideration of H.R. 2517. The amendment does not change the scope of this legislation. What we have done is gone in and amended all the benefit programs to which this bill will apply. This is the proper approach. It will help the government agencies in their administration of these programs. My amendment also clarifies the process of establishing a domestic partnership. It makes additional changes that reflect technical suggestions provided by OPM, the Defense Department, the Department of Labor, the General Services Administration, and the Office of Government Ethics. I want to thank all of these agencies for their input and technical advice and assistance, especially OPM. The changes will ensure uniform and practical administration of the benefits provided under the Act. The amendment also requires the administration to report to Congress on the implementation of the Act and provide recommendations for additional measures that may be necessary in order to carry out the purposes of the Act. I yield to the ranking member for 5 minutes for any comments he may have on the manager's amendment. Mr. Issa.
Thank you, Mr. Chairman. The manager's amendment does not appreciably change the underlying bill. We appreciate the bipartisan work that was done in order to make some technical corrections. However, as you can imagine, it doesn't change our underlying concern with the base bill or the manager's amendment, leaving vagueness in a number of areas, including, and most importantly, the gentleman from Massachusetts went on about common law marriage. Common law marriage is, in fact, common law of a state recognized by a state. This bill seeks to ignore all state law and create a new right for a new group, even if that group is not represented by state. As the gentleman from Indiana brought forth, if, in fact, there is a dispute about benefits, there will have to be a judgment, in all likelihood, in Federal court in order to do this, since state courts may say, as in Texas, for example, that they do not recognize domestic partners or gay marriage. As a result, they can't adjudicate the rights of a domestic partner who has been receiving, for example, pension benefit rights. So, although I appreciate the gentleman from Massachusetts' statement in a state that appears to be much more decided on this issue, the states that are not decided, or the states like California who have repeatedly decided against domestic marriages, may or may not be able to adjudicate the disputes. Having said that, we would like to work, and we will offer a number of constructive amendments that would allow for a support by the minority of this committee. Mr. Chaffetz has 2 amendments, one in the form of an amendment, one in the form of a study leading to better dissemination. And we have 2 other amendments that we believe would be fair and would eliminate some of the, hopefully all of the bias that exists within this bill. We hope to try to find a way to eliminate the cost of this bill while bringing an expanded set of coverage to the individuals. And I'll take just one more minute to explain in advance part of the direction we're going. H.R. 3438 is a freestanding bill that intends to give every member of America the opportunity to have the same high-quality health care benefits that members of Congress enjoy. It is a bill which has no cost to the government and is designed to eliminate questions that our existing health care reform bills do not. It allows for people to receive at their cost, either paid for by their employer or themselves, whether they are a small business or a group, the access to the Federal Employee Health Care Program, one that does not have pre-existing condition nor portability problems the way many private programs have historically had. In order to deal with the cost and the question of people uncovered, I've sought to include a shortened version of this into this piece of legislation. The amendment, when introduced, will allow anyone living within the domicile of an individual and being supported by them, whether family or not, because I don't think we should discriminate against a niece being supported by a Federal employee, a nephew being supported, or even a battered woman, sister who is escaping an abusive relationship and being supported by a Federal worker. We are going to offer that, and we're going to offer it in a way in which it has no cost to the government, but would provide the opportunity for this affordable health care to anyone being domiciled by a Federal worker. And so, Mr. Chairman, I appreciate the opportunity to offer these amendments, and hopefully they will be favorably considered, and I thank the gentleman and yield back.
Thank you, gentlemen, for his comment. I yield to the gentlewoman from Washington, D.C.
I, for one, Mr. Chairman, want to say that at the time, and some years ago, when the district's first domestic partnership bill was passed in the district, it was a very pioneering bill that didn't do much compared to what many states and cities have done on domestic partnership. At that time, the minority put a rider. It took me 10 years to get off
forbidding it, that what is noteworthy here is that bill was worded precisely as the ranking member says. Because we wanted to be on inclusive and what was not a factor there as it is here, cost, de minimis. We said it could be any person in the household who was a nephew, as you say. It could be a single mother with a grandparent, and the minority refused to allow that rider to be removed, even though in the District of Columbia at the time there were far more families who were not gay who would have benefited. So I really wonder if this was an inclusive bill, the kind, frankly, I would prefer, whether or not the minority would then say, boy, just what we wanted, something for domestic partners and for relatives or others as well. The second thing I want to say is that I appreciate that the ranking member recognizes whatever complications he thinks attend to deference to those who have not recognized marriage. But what about deference to the states that have recognized domestic partnership, and many more cities who have recognized domestic partnership and now marriage? So that if you want to really talk about complications, the existing complications are the plethora of jurisdictions that now at least recognize and give benefits under domestic partnership, not to mention the Fortune 500 companies that are so far in advance of where this Congress is.
Would the general yield, lady
I'm glad
yield?
to yield to the gentleman.
I thank her for her thoughtful comments, and would mention that when I arrived in Congress in my first term, I voted to lift that ban. And I voted to lift that ban because I believe that the control of that decision belonged to the District of Columbia, and voted with the gentlelady for that reason, that the whole local control question continues to be one that is appropriate. The district should be able to make that decision, and I voted against some of my colleagues who were prohibiting your opportunity.
Returning my time, I appreciate that the gentleman who has on occasion supported home rule did that, but the gentleman will also note that you and I were defeated in that vote, even though we were offering that kind of all-inclusive. And you would probably, I think, in light of your concern about the cost of this bill, object if we did, in fact, extend it beyond partners, because it then would cost more, and that is the major issue you have raised. I yield back the balance of my time.
Any other members seeking to be heard on the amendment? If there are no additional speakers, additional amendments will now be in order before moving to adopt the town substitute.
Mr. Chairman.
Gentleman from Utah, recognized.
Thank you, Mr. Chairman. I
5 minutes.
I have an amendment at the desk, actually, number 59.
Clerk would designate the amendment.
Should be 059 on the upper left.
Amendment to the amendment in the nature of a substitute to H.R. 2517, offered by Mr. Chaffetz of Utah. Page 63, after line 9, insert the following. Section 406, condition A, in general, notwithstanding
Mr.
any
Chairman,
other provision.
I'd ask it be considered as read.
Without objection. Gentleman is recognized for 5 minutes to offer his amendment.
Thank you. I appreciate it, Mr. Chairman. Several things have been brought up here. At the core of my approach on this is I am fundamentally opposed because of my support, my proactive, positive support for traditional marriage. Nevertheless, I do think it is one of the roles and responsibilities of this body is to act in a fiscally responsible manner. This amendment requires the President to make a determination and report to Congress that the bill will not increase premiums for existing federal employees before the bill can go into effect. As we heard Congresswoman Watson earlier mention, she talked about substantial benefits, end quote. She talked about a time to, quote, unburden some of the burdens that our federal employees are dealing with. I think it is responsible, and in fact, one of the things that is necessary for us is to understand the financial impact. There has been no nonpartisan cost estimate of what this bill is going to deal with. There's no analysis of the bill's impact on current enrollees' premiums. We simply do not know. And I think in the times of $12 trillion in debt and out-of-control spending on the perception of the American people's minds, that it is the responsible thing for us to understand some of the intended and unintended consequences of opening this up and bringing in another and new group of people. We need to understand what the ramifications are for that. So I hope, in the spirit of what this is offered, that there would be some sense on both sides of the aisle that it is our role, responsibility, and duty to truly understand the costs, and that we should study that and allow the administration time in order to move that before the implementation of the bill if it were to pass. With that, I'll yield back the balance of my time, Mr. Chairman.
I thank the gentleman for offering his amendment. I believe it is unnecessary, and I must oppose it. Estimates of the number of same-sex partners who will enroll in the federal health program are very, very small. We're talking about 15,000 to 30,000 new enrollees. There currently are around 8 million individuals enrolled in the federal employee health care system today. An increase in the population of around 0.3% would only have a very insignificant effect on premiums. Therefore, I can't support an amendment that would delay the effect of an important bill until the government points out what should be obvious. I thank the gentleman, and I want him to know that I have enjoyed working with him, and I encourage all members at this time to oppose this amendment.
Mr. Chairman.
Yield to the gentleman.
Move to strike last word.
Give 5 minutes to the gentleman.
Thank you, Mr. Chairman. As you know, estimates within the gay, lesbian, and bisexual and transgender community are that 10% of Americans fall within that category. If we are to assume that the workforce is somehow underrepresented by the gay and like community as a result of this failure to offer these benefits, and we are to assume that it will rise to the 10% often estimated by the community, then in fact we're dealing with more like 200,000 out of 2 million employees who will in fact fall within that category. So I think the Chairman may have looked at a relatively small figure, produced discretionarily, if you will, somewhat like the amount of jobs saved or created under the stimulus plan, to come up with 15,000. I believe that if we look at the number of people that the gay community chooses to pick when they choose to pick numbers and use that, we can find that this in fact could be tens or hundreds of thousands of employees times 2. So I certainly think that is to be considered, and that an estimate of 10 to 15,000 bears no scientific base or no base based on the gay community's claims of percentage of people who are gay or in some other way would be eligible.
Any other members seeking recognition? Gentleman from Illinois.
Mr. Chairman, I just have one brief comment. I remember my father telling me one time that justice delayed was justice denied, and I don't want to delay 1 minute passage or implementation of this legislation. So I think it's a thoughtful amendment, but I would be inclined to strongly oppose it.
Thank you, gentlemen. Gentleman, yield back.
I'll yield back.
Gentleman, yield back. Anyone else seeking recognition? Gentleman from Massachusetts, seeking to be recognized.
Thank you, Mr. Chairman.
Recognize the gentleman for 5 minutes.
Thank you, sir. Look, I have the utmost respect for the gentleman from Utah. He and I have worked together on a lot of issues. This is one that we clearly disagree on. From what I read in this amendment, it will require the President of the United States to confer with the Secretary of Health and Human Services and the Comptroller General, head of the GAO, to determine the efficacy of this legislation and the impact. The fact of the matter is that the GAO does not have a a role here, nor does the Secretary of Health and Human Services. And this would really, more than anything, I think, just create delay here. We have here a situation where the Federal Government, through the Office of Personnel Management, is dealing with its own employees. I don't think that bringing in other agencies is really something that will help this situation. I don't believe there's any real danger, as the ranking member has raised, of states objecting to what we're doing here for Federal employees. I think there's plenty of protection within the Constitution in the Supremacy Clause, where our laws, especially when they're dealing with Federal issues. This is us, the Federal Government, dealing with Federal employees. And I don't think that either under the Supremacy Clause or on the doctrine of preemption that states will be able to intervene to say, no, no, Federal Government, you can't treat your Federal employees this way. This is our job. This is inherent in our Federal power. This is expected. And I think it's protected very well in the Constitution. And I think that the gentleman's amendment, while well-intended,
will the gentleman yield for just one moment?
Is not meant to do nothing but create delay. Thank you. I yield back.
I was hoping the gentleman would yield if he had a moment.
Do I have more time? Sure. I'll yield to the gentleman.
Thank you. Thank you. It's not intended to just delay it. It's intended to understand the consequence to all of the other Federal employees and what it may do to their take-home pay. Now, you're trying to offer a new benefit that's got to be paid somewhere, somehow, and we have an obligation to the other 90 to 99% of the employees and understand what the impact's going to be to their take-home pay. You've got a situation now where you're asking on the backs of a lot of people to provide a new benefit. Somebody's got to pay for that. All I'm saying is it's important for us to understand that cost. Now, some may argue at whatever cost we should do this. I respect that answer. But I would also argue, and I think it's important for us to understand, that the current Federal employees who choose or don't participate in this program, that we understand what's going to happen to their check when they take it home. That's all this amendment tries to do. With that, I'll yield back. Thank you for the time.
Any other members seeking recognition? No. Well, gentlemen seek recognition. Why did the gentleman seek recognition? To move the strike last word. Right. Recognized for 5 minutes.
I thank the chairman. This amendment wouldn't affect how I view the bill. I think if I believe this was justice, which I don't believe that's the question. I believe it's a traditional issue over traditional definition of marriage. But I'm having trouble figuring out why somebody wouldn't want to know whether it increases premiums. That we're required to have PAYGO. To know whether there's PAYGO, we've got to decide if the Federal Government is paying the almost 3/4 of the cost of this, whether it's going to increase the government cost, whether it's going to increase the cost to the individuals on premiums. I'm astounded at the bills here, and we don't know that answer. I know the chairman made an estimate, presumably based on some kind of estimate of the number of people who might be eligible under the bill, but the fact is, and I question the 10% figure, but if the 10% figure, in fact, I heard members making the argument earlier that people were discouraged from joining the Federal payroll because they didn't get the benefits, which suggests that they will in the future join the payroll, and these kind of costs ought to be accounted for. I think that the gentleman's amendment is ultimately reasonable and rather astounding that we could be passing a bill without understanding and not knowing and what the impact on premiums would be. So, yield back.
Thank you very much. The question is on the Chafee amendment. All those in favor say aye.
Aye.
All opposers say no. No. In the opinion of the chair, the noes have it.
Mr. Chairman.
And the amendment is not adopted.
If I could ask for a recorded vote, I'd appreciate it.
Right. And we'll roll. We agreed early on that we would roll the votes. Okay.
Thank you.
All right. Are there any other amendments?
Yes, Mr. Chairman, I have another amendment at the desk, number 60.
Clerk will read the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2517, offered by Mr. Chaffetz of Utah.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. Anticipating great success on the vote of the previous amendment that I offered, I would also like to offer this amendment, which would suggest that require actually the GAO to conduct a study on the bill's impact on premiums and a report to Congress within 2 years after the bill has been enacted. Certainly, it would be responsible for this body to understand and be able, assuming that it were to pass, to reflect after a 24-month period of implementation to understand the consequences of what happened. So this amendment, I think, is short, it's sweet, it's to the point. I hope it's eminently reasonable, and I would urge adoption. It's just us being responsible and understanding what happened after the fact. With that, I yield back.
Well, I think a study will only reinforce understanding of the marginal impact this bill will have on health costs. I'm prepared to support this amendment. I don't think a study on health costs is harmful to the goal of this bill. I want to thank the gentleman, and of course...
Mr. Chairman?
Gentleman from Illinois.
Mr. Chairman, I have an amendment on the amendment that's currently being discussed at the desk.
Right. Clerk will report the amendment.
Amendment to the amendment offered by Mr. Quigley. Page 1 of the amendment, line 14, insert before the period the following.
Mr. Chairman.
Without objection, the amendment is considered read. The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, given your support for this amendment, I thought I would add this. My amendment would expand this GAO study proposed by the Republican amendment to also examine the effect of extending benefits to domestic partners on the federal government's ability to recruit and retain employees. As we know, the federal government is lagging behind the private sector in 19 states that offer benefits to domestic partners of employees. Many have testified to the damage this inconsistency in benefits has done to the federal workforce. John Berry, the director of the U.S. Office on Personnel Management, testified before this committee's Federal Workforce Subcommittee, where he explained that by not offering benefits to partners of same-sex employees, the federal government is not able to compete with the top U.S. companies, such as American Airlines, Chevron, Lockheed Martin, Archer Daniels, Midland, and many, many others. As we heard before, almost 60% of the Fortune 500 that offers these benefits. Mr. Berry added that the federal government does not effectively compete with these companies for every talented person when we fail to offer comparable job benefits to all of our employees. My amendment would call us to study how offering equal benefits to all employees, regardless of orientation, will affect our ability to attract and retain. The original Republican amendment I am seeking to amend strives to paint the extension of benefits to same-sex domestic partners as a burden to the federal government. And though we have no reason to believe that adding partners of same-sex couples would increase premiums, their request for a study premiums implies that adding these partners will cause premiums to rise, hurting other federal employees. Rather than depicting the addition of same-sex partners to the federal insurance pool as a loss, my amendment seeks to highlight the huge gains such an extension of benefits would bring to the federal government. Again, I seem to be making the Republicans' argument here. We're often heard that government should act in a business-like manner. I think it's safe to assume the fact that nearly 60% of the Fortune 500 companies in the United States offer these benefits, that every major university in my state, every major hospital offers these same exact benefits, dictates, at least helps us to begin to understand that what we're talking about here is operating in a business-like fashion, offering benefits that are compatible with every other workplace. And by not doing that, we're making a mistake. It also addresses the fact that businesses want their employees to be happy, and they want an environment that evokes fairness and equity.
Mr. Chair.
Gentleman from...
Mr. Chair.
I'm sorry, gentleman from Utah.
Mr. Chairman, I move to strike the last word.
Right.
Gentleman
recognized for 5 minutes.
Thank you. I appreciate the amendment. I think it's fair to look at not only the costs and the impact that this is going to have. I wouldn't necessarily call it, word it in the way that you did, but I think the amendment that you offer is reasonable. I think it's something we also ought to look at, and we ought to look at it from an analytical viewpoint, and I'd be happy to support the gentleman's amendment.
That objection, then of course I'm prepared to adopt the...
I have a potential objection.
Mr. Sada.
I wanted to ask a question, if I may, on studying the impact on employee retention and recruitment. For recruitment, do you intend to ask the question when they're applying for a job whether they're what their lifestyle is? I yield.
Mr. Chairman, I wouldn't begin to be a personnel expert. I think that obviously the Fortune 500 companies that offer these benefits have analyzed the benefits that the benefits of offering these benefits to their employees. I think that we would leave it to the experts in personnel decisions on how to analyze the effectiveness. I think it typically works after employment has begun, but I wouldn't presume to understand how personnel studies, and just the same reasons that I'm sure the proponent of the original amendment here wouldn't begin to understand exactly how it would be studied from a financial point of view, and how much money it would cost the federal government.
By reclaiming my time, I would suggest that the gentleman from Utah does know how you would study premiums, and while there might be variations, this is a can't just be done by a assertion of comparing federal employees to others, just like in the amendment to study the impact on premiums would be to compare the current premiums with any potential increases in premiums, analyzing why that premium increased. The question here is this isn't comparing the federal government to others. I don't see how you would do this without getting into the personal lifestyles of individuals who are applying for the federal government. I can see how for retention, if somebody's willing to identify and state, but if this means that you're somehow going to just do private sector number of homosexuals who work there or people of a gay lifestyle and those who are in the federal government, as opposed to actually trying to get down and look at the data like you would do in premiums, I would object to this being added, or at the very least would ask the chairman, if this is added, that there would be a little bit more clarification, because recruitment efforts suggest getting into people's personal lifestyles, which I don't believe is our business.
Right. Let me just recognize the gentlewoman from Washington, D.C., Congresswoman Norton.
First, I want to say I appreciate the spirit in which Mr. Chaffetz has apparently accepted the amendment on the amendment. I do want to say to my friend from Indiana that for years now we have perfected the art of studying what we do not know. This is a statistical matter. If, in fact, those responsible at OPM or GAO could only violate the rights of people to keep their own sexual orientation to themselves, they would be the first to tell us. So I don't think that's a worry. I would like to say a word about the competition. Mr. Chaffetz's amendment, I think it's fair to say in response to Mr. Quigley's concern that there carries the implication of burdening. I do think he's looking for the effect. I agree with the chairman that that's a legitimate matter, especially in light of the advice we have received that the effect is de minimis. Is it or is it not? Maybe there are more people than we are aware, and the GAO is, I think, a good way to tell that. Mr. Quigley's point on competition could not be more apt. We have spent years now describing how, unsexy it is to work for the federal government. With a new administration who's drawing people from the corporations, with the recession, perhaps we will draw them back. But one thing that makes it less competitive, I can tell you again, as somebody who served on the board of Fortune 500 companies, is our 70-30 contribution. We 70, 30% to them. If you look at many Fortune 500 companies, they either pay for it all or pay a much greater percentage. So we're already down, and we have not been drawing people to the federal workforce of the kind we especially need. And on the question of whether the pool will be burdened, here I will hazard a guess. I think the GAO could find this out for us as well, that this is likely to be a younger pool. The workforce of the federal government is increasingly an older pool that, in fact, does burden the insurance premiums of the taxpayers of the United States. If you draw in people who are same-sex couples, I would wager, and I think there is even a way to find out statistically, that you will be dealing with a younger pool that can only help the pool of the FEHBP. And I yield back, Mr. Chairman.
Mr. Chairman.
I'm sorry. Gentleman from California. Seek recognition for what
Thank you,
purpose?
Mr. Chairman.
Seek recognition for what purpose?
Yes, to strike last word.
Thank you.
First of all, I think the Fortune 500 isn't a model we want to use much recently. The fact is, I think AIG was a Fortune 500, and so was Merrill Lynch. But that aside, the author of the amendment has accepted the amendment as a friendly amendment, and so procedurally, I hope the Chair will accept that as a friendly amendment, and we can move on with that amendment already have been acted on by the author of the original amendment.
Thank you. Yeah.
Would the gentleman who offered the amendment, Mr. Quigley, be receptive to just measuring retention as opposed to recruitment? Because I think it would address the same question, because if we're not retaining, if that indeed is a problem, then presumably we're not recruiting too, because I see retention as something you can mathematically estimate. Recruitment is going into all sorts of general. I yield to
Mr. Chairman.
Yeah.
Again, I don't pretend to be an expert in personnel decisions, but I'm well aware of the fact that people who are in jobs in federal government and people who are in jobs in the private sector often are brought into voluntarily discussions about how they got there, what they think of their job, what can be better. There's exit interviews. There's a whole series of procedures that allow people to understand their workforce. I can't reinvent that wheel. That's been going on for a couple hundred years. So there are any number of procedures to ask people why they took this job, what mattered. You can ask people to voluntarily interview and say, what helped you decide to take this job? Yeah. What was it? Was it the benefits? Yeah. Was it who you were working for? Was it the issues you were working for? I mean, we can't spell all those out. We can't even come close in the amendment originally offered, and I understand that, and the one I proposed to alter it. I believe they can figure it out, and I don't think it'll be intrusive.
I'm willing to accept the amendment. Let me just say this, and I think we can debate this.
Mr. Chairman,
retaining my time, Mr. Chairman.
Has the time.
Yes, gentleman from California.
Mr. Sauter was requesting the time. I thought I was retaining my time.
I take it that that's a no. I just wanted to point out for the record that the federal government turnover is 1%, the private sector average is 2%, but I appreciate the ability to participate in the discussion.
Thank you, Mr. Chairman. I yield back.
Right, definitely. Let me tell you, I think that I'm willing to go along with GAO, who has in terms of survey that respects the privacy of others, and I think that we can move forward. He's accepted his amendment, so the question is on the amendment, for Quigley amendment. All those in favor of the Quigley amendment say aye. Aye. All those opposed? No. The opinion of the chair, the ayes have it, and the amendment is adopted. No. Now the question is on the Chafee amendment. Chaffetz from Utah. All those in favor say aye. Aye. All opposed? No. In the opinion of the chair, the ayes have it, and the amendment is adopted. Any other amendments?
Mr. Chairman.
Mr. Jordan, recognized.
Mr. Chairman, I have an
What
amendment.
purpose?
I have an amendment at the desk, Mr. Chairman.
Will the clerk report the amendment?
Amendment to the amendment in the nature of a substitute to H.R. 2517 offered by Mr. Jordan of Ohio. Page 79, after line 18, add the following. Title 11, Defense of Marriage Act, Section 1101, Defense of Marriage Act. Nothing in this act.
Without objection, the amendment is considered read, and the gentleman is recognized for 5 minutes to
Thank you,
explain
Mr.
his
Chairman.
amendment.
The issue at hand today is not, as some have suggested on the other side, it's not about playing favorites, it's not about discrimination. It's, when you get right down to it, it's about affirming the ideal. Affirming the ideal relationship, the ideal institution for raising the next generation of Americans, and that's a traditional family. And this amendment makes that clear. Look, the key institution in our culture is the family institution. I would argue the strength of that institution ultimately determines the strength of our entire society, our entire country. And we need to be real careful when we're as a federal government, we as a federal government are doing things that undermine that key concept. Family is the key institution in our culture, and marriage is the cornerstone of the family. The bill itself seeks to weaken the definition. I mean, and it goes right at the Defense of Marriage Act, which I would point out was passed 13 years ago in a strong bipartisan manner. The legislation in front of us seeks to not go directly at the definitions, but seeks kind of an end run and a roundabout way of creating this new marriage-like status of domestic partnership. And this is, in plain and simple terms, weakening, as I've said, that key institution. And we need to be very careful about doing that. So my amendment's real straightforward. It just says nothing in the bill, nothing in this legislation would modify, supersede, or otherwise affect the Defense of Marriage Act. And it's as plain forward as you can get, and I think it cuts to the chase and cuts to this fundamental debate. Are we, as a matter of federal public policy, going to affirm the institution which is key to our culture, key to our country? That's what's at stake here. And I would point out, just in closing, Mr. Chairman, that I think the gentleman from Utah earlier in his opening statement made a good point. Every single time this issue has went to the voters in this country, they have said marriage is what marriage has always been. Every single time. And we as a legislative body should reaffirm that key concept and not pass this bill without this amendment being adopted. And with that, I would yield back.
Let me begin by saying I thank the gentleman for his comments, but I oppose this amendment. First of all, it is not necessary and just creates more confusion. I first saw the language several hours ago and still am not sure what it really means. The gentleman claims that he's just restating existing law, but I don't think that is what the language does. I'm concerned that this language could repeal existing anti-discrimination laws. And let me be clear, this bill does not amend the Defense of Marriage Act. This legislation, at its core, is about strengthening the Federal Civil Service, which the Oversight and Government Reform Committee oversees. Whatever one's view are on this issue, the legislation does not affect or amend the Defense of Marriage Act. In fact, the bill was drafted to avoid a conflict with DOMA. This is perfectly consistent with how the law works in several states: California, Colorado, Nevada, Oregon, Washington, and others, which offer same-sex domestic partner benefits, also have provisions of law defining marriage as between a man and a woman, or explicitly prohibiting same-sex individuals from marrying. The same-sex domestic partners law do not conflict with the prohibition. There are many who believe that we should repeal the Defense of Marriage Act. Mr. Nadler, my colleague from New York, has a bill to do that, which I have co-sponsored. However, that bill is in the Judiciary Committee, not this committee. This amendment is not necessary. It adds new language that has unknown effects, and I cannot accept this amendment when we are just seeing new language and don't know what it does. I would be happy to work with you and the gentleman from Ohio and the legislative council if we need to clarify this bill further. But I oppose this amendment and urge the members of the committee to vote no.
The gentleman yield?
I'd be delighted to yield.
The gentleman in his comments said that nothing in the bill would undermine the Defense of Marriage Act. If in fact that is the case, then accept the amendment, because I will just read the amendment. Nothing in this act or in any amendment made by this act shall be considered to modify, supersede, or otherwise affect the Defense of Marriage Act. That's the point. So if in fact that's the case, why not accept this amendment? With that, I'd yield back.
Yeah, but I mean, but I want to let you know there's a little bit more. Okay, so could I now give you that? I was trying to move forward, including providing benefits to any person other than a person defined pursuant to Section 3 of the Defense of Marriage Act. You know, I was trying to move quickly because some folks said that they had some things to do, and I was trying to move as rapidly as possible. So let me at this point, if there's any other members seeking recognition, the gentleman from Ohio.
Thank you. Thank you, Mr. Chairman. And I think I was probably in Ohio when the sponsor of the amendment was in the Ohio legislature and actually voted for the Defense of Marriage Act in the state of Ohio. But this amendment does not do, Mr. Chairman, what the gentleman says it does, and I find the language actually quite confusing. So if you stop at line 7, you're right, it does what the gentleman says it does. But it's when you continue reading beyond line 7, or any amendment made by the Defense of Marriage Act. And I'd be happy to yield to the gentleman, but what is an amendment made by the Defense of Marriage Act? And I'll yield to the gentleman for a response.
I thank the gentleman for yielding. I think if you read on, including providing benefits to any person other than a person defined pursuant to Section 3 of the Defense of Marriage Act. You look at Section 3 of the Defense of Marriage Act, it has the definitions in there. That's what we want to keep intact. That's why it was included in the amendment, and that's what we need to
Taking back my time, but that's not what this says. This says an amendment made by the Defense of Marriage Act. What is the Defense of Marriage Act amending? It's not saying an amendment made prospectively to the Defense of Marriage Act, but by the Defense of Marriage Act, as if the Defense of Marriage Act in some way can make amendments to something. That's why I don't understand what this says. And I'll yield again to the gentleman for a response, but what does the Defense of Marriage Act possibly amend?
Oh, I understand. It's a typo. I'm sorry.
Oh, so, all right, so it's actually to the Defense of Marriage Act?
Yeah, and I would move to amend the amendment, Mr. Chairman, to substitute the word by.
The gentleman yield further.
To the word by.
Well, reclaiming my time for a minute. Okay, now assuming that we've changed the word by to to, you're talking about prospective changes to the Defense of Marriage Act? And I'll yield again.
Exactly, because that's the key point. The Defense of Marriage Act, passed in a bipartisan manner, affirms the ideal that I talked about. That's the fundamental issue. That's why I said that in my statement regarding this amendment. That's what we want to protect. That's what we want to defend. That's why the language is written the way it is in the amendment.
Well, reclaiming my time again, Mr. Chairman, I disagree with my colleague from Ohio that that's what this says. I agree that the first part of what he read is what it says. But the second part fundamentally changes, what the Defense of Marriage Act is. The Defense of Marriage Act is pretty straightforward. It doesn't talk about benefits. And what we are talking about here is benefits for federal government employees. If we just want to say, this doesn't conflict with the Defense of Marriage Act, I think you're right, that the language as it's written in this bill does not conflict with the Defense of Marriage Act. But the second part of this amendment, I think, goes well beyond what is the current definition of the Defense of Marriage Act, and therefore I can't support it, Mr. Chairman.
Seeking recognition.
Move to strike last word.
Yes, go ahead. The gentleman recognizes 5 minutes. Strike the last word.
Quite honestly, I'm not quite sure how the gentleman's amendment precisely impacts this. It restates the obvious, which is that to some degree the underlying premise of this bill is contrary to the Defense of Marriage Act, because it says over and over in the bill, wherever it said marriage, it has to insert or domestic partnership, meaning the benefits for marriage and domestic partnership are interchangeable. It wouldn't have to put everywhere it says marriage or domestic partnership if in fact it wasn't quasi intending the definition of marriage. That it could just say two people who are living together, but if it says they have to have a common residence, they have to have a commitment, and in fact in the section about divorce, in effect it says that if you change your domestic partner, well, if it looks like marriage and has the benefits like marriage and has like a divorce like marriage, and you're not allowing anybody who doesn't have an agreement that is certified that's like marriage, how exactly isn't it like marriage? This is the type of thing that the general public is getting fed up with in Congress. Admit what you're doing and that we have a disagreement on whether the benefits will go. But you're changing the definition of marriage. All you have to do is read the bill. The average American is going to read this and go, what in the world were they talking about?
Gentleman yields back. Recognize a gentleman from Virginia seeking recognition.
Thank you, Mr. Chairman.
For what purpose?
I move to strike the last line.
The gentleman is recognized for 5 minutes.
Mr. Chairman, I urge defeat of this amendment. I agree with our friend from Indiana. Let's be honest about what we're doing. The purpose of this amendment is to nullify the entirety of the effort here today. Line 9 makes it clear, other than a person defined pursuant to Section 3 of the Defense of Marriage Act, that is a person who is exclusively involved in a heterosexual relationship. So let's be honest about what we're doing here. This is an amendment using the Defense of Marriage Act not to be reaffirmed, but in fact to go further and nullify the intent of the legislation in front of us. There is nothing in the legislation in front of us that in any way jeopardizes the Defense of Marriage Act, protestations to the contrary notwithstanding. It is a simple task we're about here today. Shall we allow the extension of benefits to same-sex couples just as so many in the private sector already do? And the compelling reason is twofold. We have a huge recruitment problem moving out over the next decade to make sure federal employment stays competitive with the private sector. And as the economy improves, we've got so many people eligible to retire because of the baby boom demographic bulge. We have to stay competitive. This is a small but critical piece of that effort to make sure we have a more flexible workplace and we're competing with the private sector for critical skilled employees. The second reason we're doing what we're doing today, I hope, is simple decency. It's about extending rights to our fellow Americans. Rights to our fellow Americans. And it's a small step. It's hardly the end of the world. It's not a threat to anybody. It's not a threat to marriage. It's not a threat to, Republican institutions. It's extending civil rights to a small class of human beings. It's the right thing to do. And the party of Lincoln that showed us the way toward civil rights in American history ought to be on the right side of history again, not on the wrong side. I yield back, Mr. Chairman.
A gentleman from Massachusetts. Wait,
thank you, Mr. Chairman.
For what purpose?
Strike the last word.
Right. Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I just want to clarify this.
Okay, good.
The gentleman from Ohio and the gentleman from Virginia are correct as far as the impact of this amendment. The provisions that require that any impact of the Defense of Marriage Act, including providing benefits to any person other than a person defined pursuant to Section 3 of the Defense of Marriage Act, basically undoes everything that we're doing here or trying to do. Just to remind everyone, the Defense of Marriage Act not only defined marriage, it also defined spouse. So that as far as these federal employee benefits go, it can only go to a spouse of a traditional marriage, opposite-sex couple. And so if we were to limit the benefits to all federal employees based on that definition, we would basically remove any possibility that domestic partners could receive those benefits as federal employees. So I just want to be clear on the impact of this amendment, and for that reason, because I believe that these federal employees, gay and lesbian federal employees, should have the same benefits as other federal employees, I would encourage my colleagues to vote against this amendment. Thank you.
Mr. Chairman?
Gentleman from California.
Let me just say,
for what purpose?
I've watched this discussion. Strike the last word.
Yeah, gentleman is recognized for 5 minutes.
Mr. Chairman, I just sort of watched this discussion go a full circle. I mean, we started off by saying there's no conflicts at all with DOMA. There was none at all. It has been cleared and specifically designed not to have a conflict, as you pointed out. And then all at once it's come right around to, well, this will totally destroy, you know, will kill the whole bill if it's in there. Which is it?
Would the gentleman yield? Would the gentleman yield?
Yeah, the gentleman will yield.
Well, yeah, what you're saying, if you stick to the first 7 lines, it's accurate. It doesn't affect DOMA. But what this amendment is talking about is a possible prospective change to DOMA, which doesn't currently exist, with regard to benefits. So we're redefining DOMA in this amendment. DOMA doesn't have anything about benefits in it.
I would yield to the gentleman.
I appreciate the gentleman. In fact, it doesn't. The clause that's under discussion here, when DOMA was passed, there were other parts of the law that needed to be amended too, and that's what this refers to. Any amendment made by the Defense of Marriage Act to other areas of the law to make sure it's consistent and clear. That's why the language is in the bill. If the gentleman from Ohio wants to flip-flop on the defense of marriage issue, he can do that. But this is very clear what this does, and that's why we need it to pass.
Reclaiming my time before it starts getting. I'm just saying, Mr. Chairman, you clarified right out from the get-go that this bill was designed not to be in conflict. It was engineered from the beginning to avoid the conflict that now is being pointed out by members of this committee. And I'd just like to know, is it or is it not in conflict? Because the testimony today or the discussion today has been there. Will
gentleman yield?
Go ahead. I yield to the chair.
I would be willing to work with you, the gentleman from Ohio, to clear this up, because it is clear that it is unclear. You know, and I think that you know, I'm willing to work with him, because I'm sure, you know, on the floor. But the point is that under the present situation, you know, it cannot be accepted. I would not accept it.
I appreciate that, Mr. Chairman. I'm sure you came to this hearing with the intention that there wasn't any conflict, and that at least you know, we might be talking about the last 3 lines, but the initial statement of this amendment is exactly what you assured this committee of when we started the hearing on this item. And I appreciate you clarifying that, and just make sure that we have it clarified one way or the other, and that's why this amendment would straighten out this ambiguity. I yield back.
Mr. Chairman?
Gentleman from Ohio.
Will you strike the last word?
No, gentleman from Ohio. Congressman Kucinich.
No.
Thank you, Mr. Chairman.
Seek recognition?
Thank you, Mr. Chairman.
Seek recognition?
I seek recognition. I move to strike the last word.
Right. Gentleman is recognized for 5.
I want to associate myself with the remarks of Mr. Conley, Mr. Lynch, and Mr. Driehaus in expressing concern about the impact of this particular amendment. Same-sex couples face unique, systematic discrimination at the hands of the federal government already, because the federal government does not recognize same-sex marriages anywhere in the U.S., and that's what the Defense of Marriage Act was all about. Partners and children are denied the same benefits as spouses and children of opposite-sex married couples. DOMA is in itself discriminatory. I believe it's unconstitutional in that it does not provide people equal protection of the law. And it discriminates solely against same-sex couples, denying them access to over 1,000 federal protections, responsibilities, and benefits that are otherwise afforded to married couples. DOMA denies same-sex couples in committed relationships the ability to receive spousal benefits under Social Security and the ability to take unpaid leave from work to take care of a sick or injured spouse. Even in states where same-sex marriages are recognized or had been recognized, DOMA essentially prevents the federal government from providing essential benefits to citizens who are already contributing to the federal benefit system through their taxes. Now, I'm an original co-sponsor of the Respect for Marriage Act of 2009, legislation that would repeal DOMA. I'm gravely concerned that by adopting language reaffirming DOMA, that we're reaffirming a discriminatory policy that we should be working on repealing. This Domestic Partnership Benefits Act of 2009 does not interfere with DOMA in any way. The Domestic Partnership Benefits Act simply recognizes institutionalized discrimination against employees in same-sex domestic partnerships and affords them the same benefits as all other federal employees. So I'm urging my colleagues to oppose this amendment, and I'm hopeful that at some point Congress can take up the larger issue of the constitutional abrogations which the passage of DOMA involve. So with that, I yield back.
Gentlemen, anyone seeking recognition on this? Right. I recognize the gentlewoman from, pardon? Mr. Portenberry.
I move to strike the
Gentleman
last
seek
word.
recognition for?
I move to strike the last word.
Right. Gentleman's recognized for 5 minutes.
Mr. Chairman, I'd only like to say briefly that I think, frankly, this is a very constructive conversation that's going on. You just admitted, and there's a fully honest conversation now going on, that you do not support the Defense of Marriage Act. So did the gentleman from Ohio. And now we are starting to see the implications of how this particular bill is entangled with the Defense of Marriage Act. So with that, I yield back.
I didn't hear anyone else seeking recognition? Gentlewoman from New York seeking recognition?
Thank you, Mr. Chairman. And first of all, I'd like to...
You seek recognition for what purpose?
To speak in opposition of this amendment.
Right. The gentlewoman's recognized for 5 minutes.
And I move to strike the last word. Thank you. First, I'd like to compliment the author of the underlying bill, Tammy Baldwin, for her hard work and leadership, and wish to be associated with the comments of Mr. Kucinich and Lynch and others and Watson and others on this side of the aisle. I would first like to just ask my colleagues on the other side of the aisle what they mean in this amendment. The Defense of Marriage Act does not provide any benefits, to my knowledge, but in this amendment, on line 8, you say, including providing benefits to any person other than a person defined. So it, to me, doesn't... could you clarify what you mean there? Because the Defense of Marriage Act does not provide any benefits. I just would add that I've been asked many questions in my public life, but I have never been asked to defend someone's marriage. So I did not approve of that amendment, that law, but it did not provide benefits. So why are you mentioning it in this amendment? I'm just curious.
Because we have to protect the understood definition of marriage, which in the Defense of Marriage Act is the union of one man, one woman. And when you start broadening that for the purposes of federal employee benefits, you weaken the definition contained in the Defense of Marriage Act itself. That's the whole point. That's the whole discussion. That's the motivation for and the reason for the amendment I've offered.
Okay. Well, I am opposed to this amendment, and I thank the gentleman for clarifying his point of view, and I yield back my time.
Yeah, if no one else is seeking recognition, I'm prepared to vote on this. The gentlewoman from...
I just strike the last word. I'd like to just
gentlewoman was recognized for 5 minutes.
Because it was left as it was. The gentleman on the other side said that now everything is clear. The chairman doesn't support the Defense of Marriage Act, and that's what this is all about. Yes, the chairman doesn't support the Defense of Marriage Act. I don't support the Defense of Marriage Act. That is very different from saying that the language here does not affect the Defense of Marriage Act. And by the way, because of the dispute here, the course that the chairman wants to take is the appropriate one, to take this back and see if in fact there is any lack of clarity. This is the kind of stuff that can get people all bottled up in in curlicues if it were to go before a court. So I'm sure that the chairman will make sure that everybody understands exactly what we mean, but there is a difference from saying I'm against something and this doesn't affect it at all. And that is the difference I think the chairman had in mind. I yield back.
Thank you very much. Thank the woman from Washington, the Councilwoman from Washington, D.C., for her words. The question is on the Jordan Amendment. All those in favor will say aye. Aye. All opposers say no. No. In the opinion of the chair, the noes have it,
Chairman,
and the amendment is not adopted.
that's for roll call.
As it was agreed upon earlier that we would roll all votes. So,
Mr. Chairman, can I inquire how much longer you're going to roll before we have votes, or whether you intend to continue to roughly 9 o'clock tonight, which is our estimate of how long it'll take?
Well, I have no idea as to how long it's going to take. It depends on how many people, as you know, have comments, and of course, I do plan to finish it tonight, so whatever votes we have, we'll take care of them this evening, and that's the purpose. So,
thank you, Mr. Chairman.
So here again, it depends on the members as to how long we actually stay, because we do plan to finish. Are there any additional amendments after I made that comment?
Yeah. Mr. Chairman, I have an amendment at the desk.
Will the clerk read the amendment? Report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2517 offered by Mr. Issa of California.
Will the amendment be considered as read, and the gentleman from California is recognized for 5 minutes to explain.
Thank you, Mr. Chairman. And what you'll find is this has been read. I've taken the liberty of taking Mr. Jordan's well-supported amendment with some small reductions. I struck everything after the portion in line 7, 8, 9, and 10 objected to from the gentleman from Ohio and many others, who all said that they were fine with reiterating Defense of Marriage Act, but not fine with the additional language. So we now offer an amendment consistent with, we're sure, no flip-flopping, by members who supported DOMA in their states or in other places, or those who believe that DOMA will have no effect on this and that this is not a backdoor way to defeat DOMA. So as it says, nothing in this Act, in any amendment made by the Act, shall be considered to modify, supersede, or otherwise affect the Defense of Marriage Act, Public Law 104-199:110, Sat. 2419. It ends there. It's quite succinct, it's quite straightforward, and it's obviously supported by many members on your side of the aisle. And although I would certainly hope Mr. Jordan's First Amendment is accepted in its entirety, since it is well and accurately drafted by Ledge Counsel, I offer this amendment, and, Mr. Chairman, urge its support and yield back.
As I indicated early on, that it's still, unclear, and that also I'm willing to work with the other side to try and see in terms of if we can put together. But I think that this is not something we want to just rush and just sort of do. I think that we need time to look at it and to analyze it. And now I understand why you asked me what time we're going to finish. Because you keep drafting amendments sitting here, and that's not the way we do business around here. We generally get the amendment and we look at it and we share it, and then we sort of make a decision as to what we're going to do. I wasn't aware of the fact that you would be sitting up here drafting amendments as we...
if the gentleman would yield.
I'd be delighted to yield to the ranking member.
No amendment could be more, being a member of judiciary, this happens constantly in judiciary, no amendment could be more appropriate than hearing the consent and support by members of my colleagues on the other side of the aisle for a portion of a bill, if but for we would remove a small portion, and after the vote has been rolled, saying, well then, of course, since you would support the lesser and you have no problem up until that point on line 7, it begs the whole point of doing that. So, Mr. Chairman, that's
if it's going to help.
If
it's going to help, I would be honest with you. I'm prepared to accept it. But I just want to make this comment here before we move forward. This is not a committee that we draft, we bring amendments at the, we generally sort of have them before we look at them, and I just sort of like, I know I don't like to do this, but I'm going to accept this one and hope that, we deviate and don't get away from our regular procedure and sort of start deviating and getting into drafting amendments as we sit here to legislate. I think that we deserve an opportunity to see them and to look at them, and I think all members need to have that opportunity. So on this one, I'm prepared to accept it, but I just don't want to let this become a habit. And on that note, I'm prepared to yield back and to accept the amendment. Anyone else seeking recognition?
We take yes. Mr. Chairman?
Yeah.
Chairman, I have one more amendment.
Mr. Chaffetz.
Let's vote on this one. Oh, I'm sorry.
Any other member? Any other member? No.
Mr. Chairman.
Yes.
Just gratuitous comment. If I just.
Well, gentlemen, seek recognition for what purpose?
Yeah, strike the last word.
Yeah, gentleman's recognized for 5 minutes.
I appreciate what's going on here in an attempt at bipartisanship, but I have to say that I object to the gentleman's amendment being accepted by the chairman. I just want to go on the record as saying that.
Right.
I think.
Would the gentleman yield?
Sure, I would. Yeah.
Why?
Well, the bill was very carefully drafted not to even include the word marriage.
Then what's the problem?
And so adopting an amendment that says this won't redefine marriage, I think is unnecessary, completely unnecessary.
Well, if the gentleman would yield further, if it's not in any way changing the intent of the bill, why in the world would you object to it? Because we're concerned about the Defense of Marriage Act.
Well, yeah, and there are real issues, and there's going to be a real question about that, but trying to insert every single issue that you think might raise people's temperature in order to defeat a piece of legislation, I don't agree with that. If this was a real concern in this bill, it doesn't even mention marriage. You could put, whatever other raise whatever other issues you might have elsewhere in this building, and raise them in this bill, even though they're not relevant or they're not germane.
Well, if the gentleman would yield further, the Defense of Marriage Act is of great concern and importance to many people, I believe.
So is the war in Afghanistan, but I don't see any amendments on that. I mean, if it's in the bill, sure, address it. But if it's not in the bill, let's not make it up.
Would the gentleman yield?
If the gentleman would yield further, we can draft another amendment, I think, which would do the same thing and add the kind of language you're talking about, but I don't see the necessity for it. Why not just accept this? Because
would the gentleman whose time it is yield?
I'm just registering my objection, and I'll reclaim my time and yield such time as Ms. Norton might need.
I thank the gentleman for yielding. Mr. Chairman, in light of the last discussion, it seemed to me to be clear that on both sides of the aisle, there were people who had different views of the very language that the ranking member now inserts again. Some people on our side of the aisle seem to agree with people on that side of the aisle regarding what it meant in terms of defense of marriage, and then there were similar crisscrosses with some saying, no, it doesn't have any meaning. I thought, I will say respectfully to the ranking member, that the chairman's offer, in light of what was genuine confusion, which seemed to cross boundaries, that he would seek to clarify that, had taken care of that issue. So I don't see how, in light of the lack of clarity on both sides now, with people crossing the aisle to join others on where they feel, how we could responsibly vote on this as if we now knew, even though only 5 minutes ago there was disagreement on both sides of the aisle as to this very matter that is now before us again. So for that matter, I'd have a hard time responsibly saying, although I know where I stand, where I would vote, particularly since I think some members on my side of the aisle who usually vote with me don't agree with me on this matter. So why should we settle this now instead of later? And I yield back to the member.
Would the gentleman yield? I believe Ms. Spear was requesting time. Is that right?
I was, Mr. Chairman. Am I striking the last word?
I'm still on my 5 minutes.
Are you yielding to her?
I am, yeah.
Yeah, gentlewoman from California.
Thank you to the gentleman from Massachusetts. I would just like to say, along the same lines that you've just suggested, this is a terrible precedent to be setting. If we are going to insert language into every bill that comes before this committee that this is not something, when it's not germane to the actual bill, we're setting ourselves up, I think, to make bad law, because we're going to create confusion. And I don't think, Mr. Chairman, through the gentleman from Massachusetts, that we should be setting this precedent today.
Mr. Chairman, there's no question of germaneness on this.
Gentleman from Indiana seek recognition?
Yes, I do, Mr. Chairman.
For what purpose?
To strike the last word.
Gentleman's recognized.
I don't see any problem with the germaneness of this. It is germane to this piece of legislation, and it's just a question of whether or not we want to go ahead and get this behind us. You've indicated, Mr. Chairman, that you were willing to accept it, and this is already legislation that's on the books, and I don't see that it in any way impedes the intent of the bill.
Well, my good friend,
it is germane.
Would gentleman yield?
Would you yield?
Let me,
okay, to strike the last word.
Diane, it's his time.
Yeah, that's what I said, with my good friend
Yielding
yield.
to me or yielding to Diane?
I'll be yielding to the chairman first.
Let me just say this, it's a long-standing practice in terms of this committee that we don't do amendments, and as we involve in that, and I had agreed to do that. However, there seemed to be some reservations on the other side about it, and of course, I think that the offer that I gave initially, that I would work with you to try and get the language, but that so we could move forward. I mean, the point is that in our agreement to the ranking member, no, the point is that there's an agreement with us that we would try to avoid these last-minute amendments, and so this is a last-minute amendment.
Mr. Chairman, if I might reclaim my time real quickly.
Yes.
No disrespect intended, because I think you're a good chairman and you're a fair chairman, but I was chairman of this committee for 6 years.
That is you.
And when we had amendments that were relevant to the issue at hand that came before the committee at the last minute, I never said no to the minority. We had our strong disagreements, obviously, but we did allow amendments that were germane to the bill to be discussed and debated, and if necessary, added to the bill. The only thing I'm saying here, Mr. Chairman, is this is not going to hurt the bill and the intent of the bill. It just defends the Defense of Marriage Act to make sure that there's no change in that by virtue of passing this legislation. And I'll be happy to yield to, if you like, to my colleague from California.
Thank you so much, my good friend, and to strike the last word, Mr. Chairman.
Right. Are you seeking 5 minutes?
I'm seeking 5.
You're seeking your own time.
Okay.
You want to make certain. Is he yielding to you, or are you seeking your own time?
I'm seeking my own time.
Are you seeking your own time?
Yeah.
Then I'll yield back. Thank you, Mr. Chairman.
Gentleman yield back, and now gentlewoman is recognized
Thank
for
you.
5 minutes.
I just want everyone to recognize that on page 79 of the bill, the last title is Title X. This amendment that has been offered would set a new title in this bill. It's Title 11, Defense of Marriage Act. It is correct to say that the bill, as given to us several hours ago, did not have a title in the bill that had marriage in it. If you accept this amendment, you're adding Title 11 to the bill.
Would yield.
And I'll be finished in a second, my good friend. And so I just want everyone to recognize that it brings into our debate, as it has, marriage, defense of marriage. The bill, as it came to us, did not mention the Defense of Marriage Act. I just wanted to, and I will yield to my good friend.
Well, I thank the gentlelady. This was a this now is a shortened version of a published amendment that was delivered to the majority. We exchanged amendments in advance of any that we knew at the time, even though not required. It's a practice of the committee not to blindside each other, and we intend to continue doing that. So we gave that. I'm perfectly willing, as the author of this, to make Title 11 Public Law 104, 199, 110, Sat 2419, but it's still a law that we believe is appropriate to ensure as an instruction to the Office of Personnel Management that whatever their implementation is, they be consistent with that law.
I'd like to resume my time, if I might. You're very cooperative, the minority member, but I wanted to say, yes, it does change the basic bill because it adds a new title that is titled Defense of Marriage Act, and that what is spawning all this conversation that, and one member, yourself, said, are we going to be here till 9 o'clock? Yes, we are, if we continue to do this. So I just wanted to bring to everyone's attention that Title 11 introduces DOMA. It was not introduced in the original bill. Thank you. I yield back.
I want to move forward. Let me say, I was prepared to accept this, and I appreciate the offer to attempt to clarify, but there is clearly a good amount of confusion and even some animosity. And given that, I renew my commitment to work with the minority and ask them to consider, of course, withdrawing it, or if not, then we vote on it and move forward. I think
Mr. Chairman, then on that, I ask for a roll call vote on this amendment.
I have.
The question is on the ISA amendment.
Oh, yeah, Mr. Souter wanted to strike the last word.
Yeah, wanted to strike the last word. Just, thank you. That I have, as you know, and we're office neighbors, I have tremendous respect for the chairman. This is obviously an incredibly explosive issue, regardless which side you're on. And that given our kind of history of not getting amendments on the floor, our only ability to express ourselves is in committee. We don't have the ability to do it on the floor. So when it's something this controversial, this important to Americans, I think we ought to have full and flexible debate. It isn't a matter that I don't trust the chairman, but quite frankly, I have doubts that the leadership would let anything come to the floor that has the words defense of marriage in it. And in this bill, it is not true that you don't mention marriage. It is, it basically is a qualifier on the word marriage. What you've handed out here in the nature of a substitute constantly refers to marriage. It says, for example, even that the person in a domestic partnership can't be, they can't have, two individuals are not related in any way that if they were of the opposite sex would prohibit legal marriage in the jurisdiction in which the individual resides. It constantly refers to marriage. It refers to how domestic partnerships are dissolved. And that's the concern of, you could insert it, each clause, it doesn't violate the Defense of Marriage Act and show the contradiction, or you can put it at the end. But clearly, I think we should be allowed to vote to air these things. I hope that the chairman will cooperate some, and I hope that your leadership cooperates some. And if we don't like what the chairman has done or feel we got shut out, that we can offer an amendment on the floor. I yield to my friend from Indiana.
Let me just read, Mr. Chairman, from Section 3. Section 3 provides common sense definitions of marriage and spouse to reflect the long-standing meaning of those terms in Anglo-American law. While H.R. 2517 does not directly conflict with the DOMA's text because it does not specifically redefine the terms marriage and spouse, it would eviscerate the purpose of Section 3. And DOMA's legislative history makes clear that Section 3 of the statute was intended to ensure that federal benefits, tax incentives, etc., that are provided to opposite-sex marriage couples due to their marital status would not be provided to same-sex couples. As such, H.R. 2517 would thwart Section 3 intended effect. So, you know, this is very important and very relevant to what we're talking about right here.
Parliamentary inquiry, Mr. Chairman.
like to strike the last word.
Parliamentary inquiry, Mr. Chairman.
Gentleman from Virginia, yes. Yes.
I would put this question to the chair. This amendment has, with the striking of the offensive language previously objected to, as the ranking member indicated, this amendment has been presented to the committee as, I think, a simple reaffirmation of existing law. Whether we like it or not is a different question. My question to the chair is that in fact accurate? Would the adoption of this amendment as part of your bill in any way materially affect the ability to provide the benefits intended by the bill?
Right. Let me just say to the gentleman, that's not a parliamentary inquiry. I mean, but the point is that, let me just say that what I'm prepared to do, I know we have some folks seeking recognition, and then after that, I'm prepared to vote tonight on this issue. I mean, and I think that's the one way that we can resolve it. So, the gentleman from Massachusetts.
Rhode Island.
Rhode Island, I'm sorry.
He grew up in Massachusetts, though.
Thank you.
Well, thank you, if I could. I think my friend from Virginia did ask a pertinent question, and that is whether this amendment is essentially a vote on the underlying bill. It's just a substitute for voting on the underlying bill, just in a different form. And that is, and if that's the case, is this amendment really a way of inflaming the issue by putting it in a different context so as to garner kind of more of a response from folks politically by making it a more politically charged issue by introducing terms that my colleagues on the other side have introduced that are superfluous to the underlying language of the bill, which is simply about providing benefits to partners under the tax status, not introducing these terms like marriage, which, by the way, are only terms that can be brought as a result of someone's commitment through a church. This is not something that can be done through the state. This is a marriage is something that happens in a church. Okay, so this is totally superfluous. It is absolutely an effort to play upon people's prejudice, and clearly it is an offensive and very shameful political act that's going on here. And for those who are going to vote for it, I think they ought to check their conscience when they go home later on and find out whether they truly are their brothers and sisters' keeper.
Would the gentleman from Rhode Island yield?
I'd be happy to yield.
I thank the gentleman. Since I'm the author of the amendment, first of all, I was married to my current wife of almost 30 years by a justice of the peace, not in a church, and I consider it quite valid, even though it was in Nevada. The fact is that in fact,
does she feel the same way?
Time will tell, Jerry. The fact is that if you view it from our perspective, if in fact it is superfluous, but it gives comfort to those who voted for DOMA to say that notwithstanding DOMA is going to be respected, then in fact what we're giving you is an opportunity to get an easier time to have people vote for it who also voted for DOMA. The gentleman from Ohio who said he voted for it in the state.
If I could reclaim my time, we're not looking for an easier time politically or not. We're just looking to bring justice to people who want the opportunity to have the same benefits as anybody else. And that's what we're looking for. And we're not looking for people to make this an issue politically like some others are.
I thank the gentleman, but trust me, my effort was to try to make this a bill that was more clearly understood by those who had voted for DOMA, and I wish the gentleman well, but I will be voting for the amendment.
Well, the gentleman from
the question is on the.
Well, I'm trying to get the. Is it still the gentleman from Rhode Island's time?
No, do you have your own time?
I yield back. Thank you.
Yeah. The question is on the ICE amendment. All those in favor say aye. Aye. All opposes? No. In the opinion of the chair, the noes have it, and the amendment is not adopted.
I ask for a roll call vote, Mr. Chairman.
The gentleman requested a roll call vote, and as we've indicated early on, that the votes will be rolled. So, until later. Any other amendments?
Mr. Chairman.
Yes.
An amendment at the desk.
Gentleman from California has an amendment at the desk.
Mr. Chairman, I ask the unanimous consent that the amendment be accepted as read.
Without objection.
Mr. Chairman, first of all, before we go on, I want to thank you.
Let me just say. Let me just sort of make this clear, that we made an agreement that we get amendments and we have opportunity to look at them, and that we always feel that, you can come up with better and stronger legislation when you do it that way. And of course, I was asked early on, how long will we be here? And I said to the ranking member, it depends on how many amendments we have, you know what I mean? And I see they keep popping up. Initially it was 3, and then it was 4, and now it looks like it's going to be 44. But anyway, I just want to make this very clear to the gentleman as we offer it. It's better to sort of offer them in advance so we can look at them and sort of analyze it and know in terms of what we're doing. This is, serious matters, and I think it takes time. And of course, I just want to make that comment. I yield to the gentleman to.
Well, Mr. Chairman, I will not withdraw my compliment to you at trying to keep this a bipartisan effort in a very emotionally charged situation. So, again, and you're right. My amendment is in the spirit of bipartisanship. It was an observation that both the majority and the minority had what appears to be made an oversight, and I figured we get away from a very very emotionally charged issue and get to one that's much more lower voltage, and that is the issue that for 15 years, every benefit program that has been approved in that I can remember had some kind of verification system to make sure the beneficiaries were legally present in the United States. This one doesn't have it. And all this amendment does is clarify that as an employment benefit, that the beneficiaries will be checked through E-Verify before they go. That's all it says. It basically is trying to address what appears to be an oversight here, and clarifies that the tradition of verifying something that the new administration has been very aggressive on, I'd like to say compliment the administration on, and all it does, the amendment just basically says that the beneficiaries here will be checked through E-Verify before they receive the benefits. That's all it says, Mr. Chairman.
Mr. Chairman. Mr. Chairman.
Yes, the gentleman from Missouri.
Move to strike the last word. I know what I'm doing. Mr. Chairman, it's apparent.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. It's apparent that by the time I leave here, I will have to clean some mess off of my shoes from what we are becoming steeped in. When you think about the amendment that has just been offered, it has nothing to do with the underlying bill. And I'm going to yield to my friend from California so you can explain to me what the E-Verify program is. Can you, I yield to my friend.
Thank you.
Tell me what that is.
It's been the policy of the federal government, and now the policy not just for those of us in Congress and employees, but now all contractors, that benefits of employment are conditioned on E-Verify. The new administration has now made it universal even to contractors. This is basically what we've been doing since '96 in one form or the other, is using verification as a way to make sure that public funds were not going to those who are illegally present.
Mr. From my friend from California, my constituent that lives in Missouri, if they had to verify that they were a legal citizen, what would they have to produce?
It takes they show their documentation, their Social Security.
Would that be a birth certificate?
Pardon?
A birth certificate?
There's a series of it. It can be driver's license, can be certain deals. Every member of Congress, every employee in Congress uses it. Every federal employee goes through the system, and it is the fastest, most simple way. And I think that's one thing bipartisan. It's
my driver's license.
Driver's license and certain other documents like Social Security. They check they cross-check your Social Security number, and it happens within seconds. In fact, I really encourage you to go down to the employment office here. It takes less than 4 minutes to be shown and explain the entire system.
Look, I'm just amazed that we would let these ancillary issues crop up in a serious piece of legislation like this, you know, and I've heard people cite an 18-year-old law. Well, guess what, guys? No law is perfect in this country. And I don't know why we are trying to legislate a new law, not the Defense of Marriage Act and not E-Verify program. We are talking about domestic partnerships, okay?
Would the gentleman yield for a moment?
And I think you have made this a charade and taken this too far. Yeah, I yield.
The issue is that it has been the policy that you do not get federal benefits, be it employment or whatever, without verification. This is the benefits that are on this issue, and that is why we stated what has historically been the acceptable and now is accepted bipartisan as being the least intrusive way to make sure that that policy is maintained.
And reclaiming my time from the gentleman, I will still be cleaning my shoes off when this markup is over from the mess that I'm hearing in here. Mr. Chairman, I urge my colleagues to vote against this amendment.
Mr. Speaker, or Mr. Chairman,
Gentleman from
I move to
Indiana.
strike the last word.
Gentleman's recognized for 5 minutes.
If a person works for the federal government and they choose to have a friend of theirs that's an illegal alien or somebody that's here in this country illegally to be able to get permanent resident status, and they'd like for them to be quote unquote either clearly a domestic partner or just somebody they want to keep in the country, all they have to do is declare them as a domestic partner, and the person gets automatic right to stay in this country as a domestic partner. And I just think that this is something that needs to be clarified, just as my colleague from California just stated. I don't think anybody in the country wants to see benefits provided, health care benefits or anything else provided to illegal aliens, and this is another mechanism that can be used to circumvent the intent of laws that we already have in this country, and that is that we don't want benefits given to illegal aliens because the American people simply can't afford
my friend from
the cost
Indiana
of that.
Would the gentleman yield?
I'll be happy to yield to my buddy from California.
Look, history should show us, recent history, that somebody's going to say, are illegals going to get this benefit? The congressman will be able to go back to his district and say, no, anyone who gets benefits here are going to make sure they're legally present, just like our employees do. It is to assure that that is not brought up later as being a reason to say you're giving benefits to illegals. No, we're not. We've got a check in here that everybody agrees works, and thus we can assure that. So you take that off the table with this amendment. That's all I'm trying to do. I yield back to the gentleman from
Let me just say before I yield to my colleague, I'll be glad to pay for a shoe shine so you won't have to worry about your shoes.
Well, look, now who are we kidding, my friend from Indiana? I mean, look, we know that people reside in this country undocumented. We know that. But guess what? They get a pass everywhere they go. The employers want them here because of their labor. The tourist industry want them here.
Federal government doesn't give them
because of the cheap labor.
Let me just reclaim my time. Let me just reclaim my time.
You have brought an issue in that has nothing to do with the underlying bill.
Let me reclaim my time. The law is they're not entitled to benefits.
Well, you know what? They are here. They are here.
Gentleman from Indiana has the time.
Yeah, let me just say to my colleague, you can say, well, we're all winking at the law and we're letting illegals come in and do all kinds of stuff. But the law is, and we're a nation of laws, says clearly that they're not entitled to benefits. And all this amendment is supposed to do is to say that illegal aliens are not entitled to those benefits.
Gentlemen would yield, guess what? They show up at our emergency room and we treat them, okay? And we pay for that.
Yeah.
I'm not mad about it. But maybe you are. We treat them.
All we're doing is stating what the law says already. That's it.
When they experience accident.
The gentleman from Indiana has the time.
Yeah, we're lawmakers here. We're not law breakers. And unless the law is changed, we are supposed, and we swear to uphold the Constitution and the laws of this country. Now, you can say anything you want, but all this does is verify what the statutes already say.
The gentleman from
I yield back.
Don't yield back. Will you yield to me?
Spouses aren't subject
Yeah.
to E-Verify.
Mr. Chairman?
That's not.
The gentleman, the question on, Mr. Falkenberg, yes. Gentleman,
Mr. Chairman, I move.
Gentleman seek recognition?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, just a brief comment. I'm very discomforted. We are here, no matter how late it gets, to talk about hard things, to talk about the fundamentals, to talk about the policies that affect who we are as a people and where we're going as a nation. And it's been suggested that this conversation, this dialogue, this debate, which is the purpose of our republic, is somehow inflammatory. But I only find what's inflammatory to be the dismissive comments that suggest that it is not right to talk about the potential impacts of this legislation, particularly when it was suggested that those who support the Defense of Marriage Act are prejudiced. With that, I yield back.
Rhode Island.
For what purpose?
Can you start the clock? Can you start the clock now?
Gentleman recognized for 5 minutes.
Well, my point has been that if there were issues that needed to be technical in nature, and clearly the argument here is that this is a technical issue that needed to be brought up, then why wasn't it brought up before the bill was brought up? And the reason is this isn't a technical issue. This issue is being brought up for the same reason the Defense of Marriage issue was brought up, to play on bigotry. We're targeting and playing upon the prejudice against immigrants now. Let's lump the gays in now. Let's make gays and immigrants the target. I mean, let's have a free-for-all. Who are we going to make the target of bigotry against next? That's my point. Unless you guys don't get it, it's pretty transparent what's going on here. If you honestly think that we're really debating the merits of E-Verify, then I'm sorry, if you don't politically understand that this is really about immigration and your attempt to vilify and shame this notion of, and you're even calling them aliens. I mean, come on, they're people. They happen to be undocumented. They're people. You're calling them aliens. Now, there's no small wonder why, you know, people, there's actually a movie out right now where one of the characters says, I can't believe they're deporting me. I'm an immigrant, but I'm from Canada. That was actually the movie. It's called Proposal. They just deport this woman from Canada. She goes, I can't believe they're deporting me. I'm from Canada. Well, you know, the irony is that we don't think of immigrants when they come from Canada. We think of them when they come from South America because of the color of their skin. And if you don't think this is about bigotry because of sexual orientation, you don't think this is bigotry based upon race, and if you don't think this is bigotry on immigration, then you guys just, you know, I'm sorry, I've underestimated your political prowess.
Mr. Chairman, point of order.
Political prowess on
Mr.
these
Chairman,
issues.
point of order.
Now yield back the balance of my time.
Thank you, gentleman.
Mr. Chairman, I ask the members' words be taken down. He has directed it toward individuals and toward their reasoning for doing it. The author of the bill is by definition disparaged by these comments. I would ask the gentleman either to restate correctly his objection to the amendment or that his words be taken down.
What was the words? I mean, yeah, and who's in there? I don't know.
Mr. Chairman, I would ask the words be read back then.
No, I mean, I didn't hear this. I mean, you know, individuals. Did he name somebody? I mean, I didn't hear this. Huh? Yeah. Yeah. Well, let me, first of all, I mean, I must admit that I did not hear in terms of individual, but there is, in terms of no provisions to take down words in the committee. You know, so I would suggest that we move on, but I really did not hear in terms of him indicating any specific person.
Mr. Chairman, I move to strike the last word.
The gentleman recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, amendments are made in committee. Amendment to state what is already in the public law should not ever be disparaged by any member as to its motivation. The stating of public law by my gentleman and friend from Rhode Island as though it was disparaging immigrants or disparaging people because of their color, in my opinion, is grossly inappropriate, and I am sorry to say that I believe the gentleman's desire to protect and defend issues has overtaken him tonight. So I'm withdrawing the whole question of taking down the last words. I realize that it's very difficult for them to read them back in real time, but I think all of us who heard it here tonight, and certainly the C-SPAN audience, if there is one, or our tape, will reveal that, in fact, we have exceeded perhaps the hour that we should be working, and as a result, tempers are rising. The gentleman from California sought an amendment to state E-Verify, which has long been in our law, both as a planned program and now universally, that it be implemented so that if somebody were naming a spouse, or let me rephrase that, if somebody were naming a person to receive benefits, that that person be legally in this country. I believe that, in fact, that is a just and appropriate amendment. I would hope the Chair would accept it and that we would not even have to go to a recorded vote on something which, to be honest, every Federal employee goes through. So asking whoever is part of their extended benefit package go through it is not unreasonable. But I also would hope, on both sides of the aisle, that we think twice before we allow our passions to get ahead of us again. Mr. Chairman, I appreciate your understanding.
Would the gentleman
and I yield to the author of the amendment, Mr. Beltray.
My point was that both sides had overlooked the fact that it is the law today that if you're not legally present, you do not receive these benefits, underemployment or either. And the gentleman, my good friend from Rhode Island, I'm sure was not directing those references over to me. We've talked about it. My feeling here is that this is the clear kind of message that Washington needs to give again and again so we do not have the mixed message. And for the record, Mr. Chairman, you know, there is a unique experience growing up on the border, being maybe the only member of Congress who've rescued people crossing the border illegally, recovering their bodies, and seeing the personal cost that us sending mixed messages in the past. And I'm very proud that Congress on both sides has looked to E-Verify as a non-intrusive, non-punitive way of addressing the problem, and that is don't go after the immigrant, but go after the people providing the incentive for the illegal immigration. And that's why E-Verify has always been the middle ground that both